Let's get into this conversation now. The Information Regulator of South Africa is standing by its argument that the publishing of matric results violates the privacy of pupils. Now, this is despite the Pretoria High Court throwing out its urgent bid to stop the Basic Education Department, saying it had years to challenge the matter. Let's get some perspective now, and we speak to the regulator herself. Advocate Pansy Tlakula is the chairperson of the Information Regulator. Advocate, good afternoon to you, and thank you for your time. We'll get to grips in a moment about where to now, but I just want to start with the previous interactions we have had with you. And I remember at one point you were quite steadfast that there was no legal justification for the Department of Basic Education continuing to publish the matric results in the media. What do you say today after that particular judgment?
Well, we stand by the orders that we gave to the Department of Basic Education in our enforcement notice, which we issued in November. Now, I think the context is important, particularly in relation to what has happened today. You'd recall that we issued an enforcement notice, and in the enforcement notice ordered the department, among others, not to give us an undertaking that they will not publish the matric results for the 2024 matric learners. The department then responded to say that they are going to continue to publish because they have a court order which they obtained in 2022, which compels them to publish the results. The enforcement notice of the Information Regulator is binding unless it is set aside on appeal, but also the lodging of an appeal suspends the enforcement notice. We now know that the department tried to appeal, but their processes were not complete. They lodged their papers in court, but they did not serve us with those papers. So that was not proper service in terms of the court rules. So from where we stand, there is no appeal which the department has lodged, which therefore means that our enforcement notice remains legally binding on the Department of Basic Education until it has been suspended either by the lodgement of the appeal or set aside by the court on hearing the appeal. So that's where we are.
Advocate Tlakula, this is very confusing because
it's not.
On Monday, the department is going to release these results. Are you saying that despite this court judgment, which, by the way, as you said, context is important, today the judge limited herself, so to speak, to the urgency of the matter?
Exactly.
Now,
exactly.
You are saying that your order, which prevents the department from publishing these results in the media, you're saying that that cannot go ahead. Am I hearing you correctly?
I'm saying we issued an enforcement notice. This context is important because we went to court to apply for this interdict because the department had informed us that they will go ahead to publish the results despite our enforcement notice. So we're going to say you can't ignore the enforcement notice. The enforcement notice, it is there, it is binding, it remains binding, irrespective of what happened today in court. What happened today in court is something else. So until such time that they have appealed against that enforcement notice, it remains binding. In fact, post the enforcement notice, because they did not apply for, they did not serve us with papers, they did not apply for an appeal, they did not appeal our enforcement notice. Post that, you must remember, we issued an infringement notice in which we fined them 5 million rands. All that stand until that time, such time that the department approaches the court to appeal against our enforcement notice.
Let
So
me be
that's the
clear.
legal position. It's very clear.
Let me be clear. Let me be clear in my line of questioning. So I'm glad that you've brought up the infringement or the penalty that they suffered previously. If
Yes.
they publish these results come Monday, are you saying that perhaps another 5 million rand will be due to the Information Regulator as a result of yet another infringement?
No, it's a single infringement, one infringement that arose as a result of the enforcement notice that we issued. So we issued the enforcement notice. We said, please give us an undertaking. You will not publish. They did not give us that undertaking. And then they said that they will publish. They did not appeal our order within the time that was stipulated in that order. And when their time prescribed, we issued an infringement notice. That notice stands unless they go ahead and apply to appeal our decision. In fact, even in their papers, they do admit to the fact that they did not serve us on time with the papers. They still even said they still have to approach the court for condonation for late filing. Those things still have to happen until they apply for condonation for not serving us, until the court hears the application and grants the condonation. Until all that happens, the orders that we issued remain legally binding.
Okay.
Today's court judgment that threw us on agency did not affect the main case.
Okay. A little later, I will be talking to the Minister of Basic Education. If and when I talk to her, and she says, we are going ahead with the publishing, and this has nothing to do with the court processes, what will your next step be?
I mean, the next step lies with the department, not with us. With us, we have issued an infringement notice that is binding. People who have to act is the department, not us, not the Information Regulator.
Are they allowed to publish these?
Well, the court has thrown us our application interdicting them from publishing. So yes, they will publish.
Yeah.
But that publication has got nothing to do with the enforcement notice that we have issued and the subsequent infringement notice. And I repeat, the enforcement notice is binding until it has either been set aside by the court or suspended through an application for appeal brought about, instituted by the Department of Basic Education. There's no appeal against our enforcement notice as we speak. Maybe let me say so. There's no appeal. So because there's no appeal pending before any court, therefore the enforcement notice and the infringement notice remain legally enforceable and binding.
This is very interesting. Let's get to grips with the merits of the case, if we can.
Yes.
As I understand it, Advocate Tlakula, the department failed to comply with Section 11 of the POPIA by failing to obtain consent from the learners themselves if they are 18 years and above. If they are under that age, then a guardian can give that consent.
All right.
Are you saying that it is on the basis of exactly this that that infringement notice or the enforcement notice was therefore issued against them? What are you trying to force them to do, and what have they said in relation to that?
I'm glad you're putting this in context, because the narrative out there is that the Information Regulator says the department cannot publish matric results in the newspapers. That's not our order. We say you can publish provided you obtain parental consent, because even if you publish by using an examination number constitutes personal information. And because it is personal information, it has to be processed in compliance with POPIA. So POPIA says you don't have to obtain consent if you can prove that publication of these results protects the legitimate interest of the learners or pursues the legitimate interest of the department, or there's a law which allows them to publish. Now, we have looked at all this. We have given them the opportunity to respond to our initial findings. We have found no law which says they must publish in the newspaper. They could not prove to us the legitimate interests which they are pursuing by publishing or protecting by publishing the results of the learners in the newspaper. So because of that, if these three grounds do not apply, then consent kicks in. You have to then obtain consent.
Yeah.
So that's really our finding. But I'm saying, having said all this, I think it's important also to say this is contained, these are our findings in the enforcement notice. Should the department appeal, these issues will then have to be ventilated in court, the merits of this case.
Yeah.
Whether we are correct in our interpretation of POPIA or whether they are correct in their interpretation. And our view is that I think it's important for the courts to begin to establish jurisprudence in this country on POPIA, because POPIA is a new piece of legislation. It has not been tested in court. So we welcome, and I'm sure the minister also welcomes, the fact that it will be good for all of us as South Africans if the court engages with these issues, assists us in the interpretation of POPIA, so that we come to a conclusion once and for all. And next year, this time, we should not be talking about the same thing.
Well, I'm glad that you invoke the legal fraternity or the legal jurisprudence around POPIA, because the judge today says it would seem to her that this does not have the interests of the learners at heart. All that this is about are the interested parties, yourselves, the department, and those that have applied to court to be amicus curiae. So how do you respond to the judge saying that you say you're fighting for the protection of the privacy of the learners, but in actual fact, this is less about that, because you took your time, by the way, to even bring such matters to court?
Well, I don't want to be arguing with the judgment of Judge Tolmay. All that I'm saying, or all that I can say, is that we have an act called the Protection of Personal Information, which says whoever processes personal information must comply with that act, private and public bodies. That's all that we are interested in. And the act itself has exceptions, it has exemptions. It provides for balancing of the rights, the right to freedom of expression, the rights, free flow of information and privacy. So the judge was correct in saying that this matter is complex because it involves the balancing of rights, and therefore it cannot be dealt with on agency, because the court has to engage with all those complex legal issues. Very quickly,
Advocate Tlakula, student numbers is what the department is going to publicize. Is that not enough a measure to protect the privacy of the students?
We've said before, Xoli, that those numbers are sequential. Students sit sequentially in the exam room, and the results are published sequentially on the newspaper. If you are number one, you sit in front. I'm number two, I sit behind you. And when the results are published, we'll be number one, number two. I'll know your results and you'll know mine. So it's not anonymized.
Advocate Pansy Tlakula, thank you very much for your time. A very tough lady she is, I've got to tell you.